Before we take roll, actually, let's take roll first. So, Lisa?
Sure. Chen,
Here.
Cisneros,
Here.
De La Cruz, Duran, Iglesias,
Here.
LeBron,
Here.
Pertula,
Here.
Selig,
Here.
Stalling,
Here.
Steinbrecher.
Here.
Okay, we have quorum.
All right. So welcome to all the members of the public. Just as a way of introduction of today's agenda, we're going to be taking the closed session out of order, and that will be at the end of our open session items. So Jeff, if you're on the line, if you have something you need to do, we should be going over to you in about 45 minutes. So we will now go into call for public comment. Are there any members of the public who wish to make comment? I think, and with this format, you still need to raise your hand and you'll be promoted. And if you could, identify yourself and then keep your remarks to about 3 minutes so all members of the public can be heard. So are there any members of the public who wish to give public comment right now? Lisa, do you see anybody raising their hand or indicating?
I'm not the host of this meeting. Maybe our staff can tell us. Lisa, Ellen?
Sorry about that. I've got a view on the public and I do not see any raised hands.
All right. So we will go to the chair's report. Good morning again, everybody, and welcome to the final meeting of our 2019 and 2020 RAD committee. I'm extremely proud of the work that this committee produced and for the diligent and effective work of our staff. As you all know, the mission of the State Bar is public protection, and the RAD committee is charged with ensuring that members of the public are protected and that we do so in a way that instills confidence in the legal system. To that end, the State Bar has taken on several projects in the preceding years that have had great import on the discussions going on in the world today regarding questions of justice, fair and just enforcement of the laws, and the impact that enforcement of laws have on minority communities. The California State Bar has taken the lead on examining these issues, even before they gained renewed national attention this year. This body has taken deliberate and judicious steps to ensure confidence in the legal system, all while keeping public protection as the paramount important. RAD was tasked with implementing several reforms and examining other reforms as recommended by Professor Robertson. Later on in the agenda, under discussion of work plan, as well as the full Board of Trustees agenda, we'll have discussions in the areas of the implementation of archiving complaints, reportable actions involving bank matters, respondents' representation of counsel at trial, and the communication with respondents about the importance of retaining counsel. OCTC has continued to refine their practices and improve efficiency in the context of a global pandemic and the implementation on a very short timetable of working remotely. OCTC, through the vision of Steve Moad and Melanie Lawrence, have continued to refine the case prioritization system and ensure that the funds entrusted to us by the legislator and our licensees are utilized in a manner that protects the public and those most vulnerable in California. We have directed staff to continue to work with law enforcement agencies and district attorney offices in the area of the unauthorized practice of law. OCTC has protected the most vulnerable in California through their use of seizing unlawful law practices and helping those who have been affected by this fraudulent conduct. We continue our outreach into minority communities about the dangers of notarios and those who hold themselves out to be engaged in the practice of the law unlawfully. It takes a massive amount of effort to implement public protection, and leading the way in RAD is Lisa Chavez. Thank you for your clear communication and for keeping us on track. Thank you to all of the staffers that work on RAD, including those in Oriah, Dag McLeod, and Ron P. Your work is immensely important, and we are extremely appreciative. For Hatim and your team and looking at the use of technology to ensure fair and just prosecution, to Steve Moad for your continued vision and your diligent work, and for Melanie Lawrence in inspiring change and leading OCTC in this tumultuous time. To my vice chair, Ruben, I think he had some technical difficulties, but hopefully he's listening in. Thank you to Ruben for your enormous help in all of these areas and your perspective. And finally, to Alan Steinbrecher, Sean Saleg, for entrusting me with this committee. Alan, your steady hand of leadership and your wealth of experience will be missed. And I don't know if this is the proper Navy send-off, but bon voyage. So with that is my report, and we will go into the consent agenda. Are there any members of the public, or excuse me, any members of this board who wish to take any of the 3 items off the consent agenda? Okay. Because they're on consent, I believe that it does not require a first or a second. And is there any objection to substituting the roll call?
Mr. Chair, no objection. This is Ruben just making my presence known. Good morning.
Good morning. Welcome.
Sorry, I think you have to take roll.
Yeah,
Oh, yeah.
you do since we're telephonic, yeah.
I'll take roll. Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Petula,
Yes.
Saleg,
Yes.
Bowling,
Yes.
Steinbrecher.
Yes.
All right. Items on the consent agenda are approved. Moving on to business item 3A is proposed amendments to rules and proposed new rules regarding electronic service and electronic signatures. This is a return from a public comment and request for approval. And on that, we have Steve Moad.
Good morning. Thank you all. This item was submitted to a 45-day public comment period following the July RAD meeting. As you may recall, this was one of 2 items that were initially brought as one item to the July RAD meeting. They were separated during that meeting and sent out separately for public comment. The proposed rules were the subject of several bench bar committee meeting discussions, and we also considered separate feedback from the State Bar Court and the Association of Discipline Defense Counsel on these proposals. While we were unable to reach consensus on all issues, we tried to address many. The primary remaining point of disagreement in this proposal is that Rule 5.26.2 is deemed to be too convoluted, and Government Code 16.5, to which it refers, is antiquated. And we do not necessarily disagree that the Government Code 16.5 is very technical, but we have tried to mitigate this by allowing several alternatives to Government Code 16.5 type of validation of signatures. First of all, the definition of electronic signature in Rule 5.4 paren 30, or proposed Rule 5.4 paren 30, includes, quote, a copy of an original signature placed into the document by electronic means. This is essentially a scanned image of a signature. And also includes a typographic signature that includes /s/ followed by the signer's name. So those are 2 alternatives which are permitted under these rules. Such signatures are permitted on documents that do not have to be signed under penalty of perjury when they are submitted by the signer of the documents or the person acting at the signer's direction. Even in documents signed under penalty of perjury, proposed Rule 5.26.2 paren C permits the use of such a signature when the document is submitted by the declarant or the declarant's counsel. Finally, State Bar Court expressed a desire not to adopt new rules regarding electronic service until e-filing is available. And the court's position on that is that there will be at least 4 sets of rules of procedure revisions in a short period of time. There were the pre-COVID rules, the interim COVID rules, these proposed rules, and then any changes after the implementation of e-filing. They also believe that revisions to the rules of practice may be necessary in light of the various changes to the rules of procedure. and the court is concerned that multiple rule changes may be confusing for respondents and their counsel. OCTC agrees that ideally fewer rule changes would be required, but notes that the timeline for e-filing is unclear and believes that it is appropriate to move forward at this point. On that point, I would point out that the court asked that we delay implementation of any new rules until October 30th in this proposal, and that is why we have asked that the new rule not go into effect until November 1st in the proposed resolution of this item. As to public comment, we received 2 public comments during the public comment period on this item. One person stated their agreement with the proposed changes without comment, and the other also indicated their agreement and provided the following comment, quote, "Permitting electronic service of documents is a good policy. Paper has its place, but the environmental costs of personally serving documents are needlessly incurred. It infuriates me in my practice when sophisticated entities and counsel refuse electronic service, as there is no need to print and waste paper when everybody will end up reading an electronic copy of materials anyway." Close quote. So with that, I'm available for any questions, but would urge adoption of the resolution of this item.
All right, does anybody have any questions of Steve? One thing I would also note is that we have been looking at the implementation of an e-filing system, an electronic management system that would assist the State Bar Court in this endeavor. So we are continuing to get those quotes and see which options are best, and I think that we'll be reporting on that in the near future. All right, any other questions or discussion? I think everybody's
I move the resolutions.
okay. Thanks, Alan.
Duran, I'll second.
All right, I have a first by Alan, second by Ruben. Any further discussion? All right, Lisa, please take the roll.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Petula,
Yes.
Clegg,
Yes.
Colling.
I don't vote unless in a tiebreaker.
Okay, gotcha. Steinbrecher.
Yes.
All right, item passes. Thank you. And then Steve, before you get up in a Zoom sense, item B, proposed amendments to rule of procedure regarding electronic trial exhibits. And this is a return from public comment and a request for approval. Steve.
Yes, thank you. This is the second agenda item that was separated out from the unified RAD agenda item at the July meeting and sent out to a 30-day public comment period following that meeting. This item permits the exchange of electronic exhibits and removes from the rule 5.101.1 the requirement, excuse me, the requirement that we provide to the court the exhibits in paper format with tabbed binders, and instead permits the court to elect the format of exhibits. It also allows the exchange of exhibits between the parties in an electronic format. Again, this item was subject to extensive discussion with both the court and the Association of Disciplined Defense Counsel. Again, we considered their feedback. We were unable to reach consensus on all aspects of the proposed rule changes. For example, the court expressed a desire to maintain the requirement that the court be given a paper copy of the exhibits in a tabbed binder with labels. And if the parties exchange electronic exhibits, the court would also like to receive an electronic copy of those on a thumb drive or some other electronic medium. OCTC, however, is concerned about enshrining in the rule a requirement that the parties provide the court with additional exhibits in paper format. and instead proposes a more flexible approach that still permits the court to order the parties to provide a paper copy in individual cases. We received 4 comments during the public comment period for this item. 3 of the 4 respondents stated their agreement with the proposed changes without comment. The other commenter said she would agree with the proposal if it were modified to permit the use of original evidence where a copy is not typically used. OCTC's proposal does not change the format of the original exhibits, which have been and will continue to be lodged with the State Bar Court for use of the Supreme Court. The rule change only addresses the format of the exhibits exchanged between the parties and those provided to the State Bar Court for use of the court. As a result, OCTC does not believe any modification is required in response to this comment, and again would urge adoption of the resolution for this item.
Mr. Chair, if I may just supplement for 1 second.
Yes.
So I do, out of respect to the State Bar Court, I would like to say that it's a slight understatement to say that the State Bar Court expressed a desire to have the both an electronic and a paper copy. The State Bar Court believes very strongly that for its processes, it needs a paper copy and an electronic copy. And so this is something where OCTC and the State Bar Court came to a disagreement. As Mr. Moet explained, OCTC and the agenda item talks about OCTC did not want to enshrine that in sort of perpetuity in the rule that both a paper copy and an electronic copy would be provided. And he stated that the State Bar Court could still order the provision of a paper copy. The State Bar Court is a court that operates on paper, right, without the electronic filing system that you've talked about. And so as part of that, the court does believe that it needs both of those. And I just wanted to make sure that the committee heard that part clearly on behalf of the court.
Yeah, and I would just echo that I've been involved in the discussions with State Bar Court and have heard their concerns. I've talked about this extensively also with Steve and Melanie. And Steve, one of the things that came up in our discussions was the court having a set of orders that they put forth before each trial. And so if you could just talk to Rad about what those orders encompass.
Of course. So as I mentioned, the court would still be free to order the parties to provide exhibits in any format that it chooses, including, for example, more than one copy of the exhibits. They could order the parties to provide the exhibits in both paper and electronic format. And of course, we would comply with any court order requesting that. That is something that is standard on all cases that are going to trial. They do issue in all of those cases a general pretrial order, which frequently addresses many aspects of the trial, including exhibits, and that's what we have been receiving recently from the State Bar Court regarding exhibits. And that's fine. As Donna mentioned, it is important to the State Bar Court. And to the extent that they continue to require paper copies, we will continue to comply with that order. Of course, the hope is that as time progresses and people and institutions become more comfortable with digital copies of items, that will no longer be the case, whether that be 6 months or a year when electronic filing is available, or 3 years in the future, or whenever. But at least at that point, the rule will not be requiring something that is no longer necessary. So those pretrial orders are standardized, or at least standardized by individual department or judge, so long as we can determine. And so they could make that order however it is that individual judge prefers.
I do want to raise one other thing that I neglected to in my chair report, but the State Bar Court has really done an incredible job of conducting hearings and now trials over a video system. Is something that they've adapted to really on the fly and have just put an enormous amount of work into, have been extremely flexible in their approach to working with the defense bar and with OCTC and the different challenges of implementing video trials. So I see the dual use of either paper or electronic exhibits as really furthering that goal of modernizing the state bar and state bar court, and really leaves open to each individual judge what they would like to do. Some of these cases, especially the paper cases, produce voluminous amounts of records, and I think it's always good to keep stewardship principles regarding the community or the environment rather in mind in some of those voluminous record cases. So this provides that flexibility, and nothing about this rule prohibits judges from asking for that second paper copy. The first paper copy will go to the Supreme Court. The second paper copy could be used by the trial court. Are there any questions for myself or Steve or anybody else? All right, hearing none, may I have a motion to approve?
So moved, Duran.
Second, Steinbrecher.
Okay, first by Ruben, second by Alan.
Okay, so we'll take roll now. Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Petula,
Yes.
Blake,
Yes.
Steinbrecher.
Yes.
Okay, motion carries.
All right, great. Thank you, Steve, and everyone
Thank
who
you.
worked on this this rule. Definitely a mountain of work, and thank you for being responsive in this. All right, going on to item C, amendment to rules of procedure governing fee arbitration award enforcement proceedings. And this is a request to circulate for public comment. And we have Mark Schopp, who's presenting on that.
Good morning to the committee. This is Mark Chapp. I'm an assistant general counsel. This item proposes to present for public comment rules or an amendment to the rules governing mandatory fee arbitration enforcement proceedings in state bar court. The presiding arbitrator's enforcement authority includes bringing an action in state bar court to seek involuntary and active enrollment of an attorney who has failed to pay a fee arbitration award to a client. The state bar has been subject to some federal litigation on this, and the Ninth Circuit has found that fee arbitration awards are dischargeable in bankruptcy as a general matter. However, the rules do not provide a mechanism to either abate enforcement proceedings or to reverse the inactive enrollment of an attorney based on the discharge of a fee arbitration award in bankruptcy. So these amendments are intended to allow the presiding arbitrator to do just that. And this rule was developed in consultation with the presiding arbitrator, the mandatory fee arbitration program staff members at the state bar, and also with input from state bar court.
All right, excellent. Are there any questions for Mark? All right, any discussion? All right, may I have a motion?
So moved, Duran.
Second, Chris Iglesias.
All right, first by Ruben, second by Chris. Lisa, please take the roll.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Petula,
Yes.
Blake,
Yes.
Steinbrecher.
Yes.
Okay, motion carries.
All right, thank you. All right, next is item D, proposed amended rule of professional conduct 5.4. This is a return from public comment and request for adoption. And on that, we have Andrew Tuft. So welcome.
Thank you. Good morning, everybody. This amendment to Rule 5.4 was initially developed by the Task Force on Access Through Innovation of Legal Services, also known as ADJOURN. And ADJOURN recommended that current paragraph A5 to the rule be amended in order to extend the existing exception, which permits a lawyer to share court-awarded fees with a nonprofit organization, to include an exception providing where the legal fee is not court-awarded, but arises from settlement or other resolution of the matter, the lawyer may share with or pay the legal fee to the nonprofit organization, provided that the nonprofit qualifies under Section 501c3 of the Internal Revenue Code. This exception is patterned after the District of Columbia Rule 5.4, which has a similar provision. Because the ADJOURN Task Force sunset on March 31st, the board directed the Committee on Professional Responsibility and Conduct to receive and review the public comments submitted. And the rule went out for an original 60-day public comment period in March. In July, after reviewing those initial public comments, COPRAC recommended that the rule be amended by breaking out this new exception into its own subparagraph A6, and by adding a requirement that the lawyer must comply with the provisions of Rule of Professional Conduct 1.5.1. Back in July, RAD authorized an additional 45-day public comment period for the rule as amended, and this most recent public comment period ended on August 28th. 39 written comments were received concerning Rule 5.4 as revised. 27 commenters opposed the rule, 3 supported the rule, and 9 supported the rule if modified. In consideration of the public comments, COPRAC noted that the comments included observations that the proposed rule both underregulates as well as overregulates the type of fee sharing contemplated. And I do want to note, as stated in the agenda item, one of the commenters who believe the proposed rule underregulates this form of fee sharing is Assemblywoman Lorena Gonzalez. But after considering all of the public comments received, the committee believes the proposed rule strikes a fair balance between these two concerns. The committee determined to leave the black letter text of the proposed rule unchanged, but has added clarifying revisions to the comments in order to address some of the concerns raised by the commenters. And my presentation will focus on the majority of these revisions. And so common points raised by the public comments included the following. First, several commenters disagree with the concept of nonprofit organizations sharing legal fees with lawyers at all. And they also were concerned that the proposed rule might result in unscrupulous lawyer referral activity. The committee's response to these concerns was that first, case law and the rules of professional conduct, as I mentioned, currently recognize a special fee sharing arrangement involving lawyers and qualified nonprofit organizations with respect to court awarded fees. This proposed rule's purpose is simply to extend the ability of a lawyer to share fees with a qualified nonprofit organization in circumstances where the legal fee is not court awarded, but arises from settlement or other resolution of the matter. And this would be subject to specified requirements, such as that the nonprofit qualifies a 501c3 and that the lawyer obtain the client's consent in writing to the fee division. Regarding unscrupulous lawyer referral activity, the committee noted that the laws and rules governing lawyer referral activity, including restrictions on a lawyer paying compensation to a person or entity that is conducting a referral business, are not intended to be changed by the proposed amendments to Rule 5.4, and none of the language of the rule evinces such an intent. Nonetheless, the committee has added a comment making this explicitly clear, and a new comment 5 is added to the proposed rule, which states, quote, "Nothing in paragraphs A5 or A6 is intended to alter the regulation of lawyer referral activities set forth in Business and Professions Code section 6155. In addition, a lawyer must comply with rules 5.4A4 and 7.2B. Next, a few commenters believe that the term qualifies under 501c3 of the Internal Revenue Code is vague, and that the rule should require that the organization possess an IRS tax exempt determination letter, both at the time that the agreement to divide the fee is entered into and at the time the payment is made. In addition, some commenters believe the rule should require that the nonprofit has a quote unquote confirmable mission aligned with the purposes of the litigation. Concerning whether the term qualifies as vague, the committee noted that the rule would only apply to bona fide 501c3 entities that are recognized by the IRS. And certain organizations, such as churches, do not need to receive a determination letter in order to qualify as a 501c3. In addition, the proposed rule is patterned after District of Columbia Rule 5.4A5, which also uses the term qualifies, and the committee is unaware of any unintended consumer harm as a result of that term in the District of Columbia. And finally, because California recently went through a concerted and detailed effort to align our rules of professional conduct with the national standard where appropriate, and although it's only one jurisdiction that currently has this exception, the committee values maintaining such a standard where possible. With respect to the suggestion that a nonprofit organization must have a confirmable mission aligned with the purposes of the litigation, the committee did not believe such a limitation was warranted. The current exception for fee-sharing court-awarded fees with a nonprofit organization is not so limited, and current comment 3 to the rule states the qualifying nonprofit organizations that may share a court-awarded fee include, quote, nonprofit legal aid, mutual benefit, and advocacy groups that are not engaged in the unauthorized practice of law, close quote. The committee believes the requirements that the organization qualifies as a 501c3 and that the client must consent in writing to the fee division provide substantial client protection. However, the committee has made 2 revisions to comment 3 in order to clarify potential confusion. Specifically, they deleted the phrase, quote, and other nonprofit organizations, which had been added to the list of the qualifying nonprofit organizations I just noted. That phrase was added in the amended rule that went out for the second public comment period in order to capture law practice incubator programs, as I described in the agenda item. But that phrase, upon reflection, may have resulted in unintended confusion because the term other might have implied that any nonprofit organization may share a legal fee with a lawyer, and that wasn't the intent. And so in order to address that concern, the committee has added 2 sentences to the end of comment 3 in order to clarify exactly what is intended by the addition of the word facilitate. And second, the committee chose to revise the second sentence of comment 3 to read in parallel with the first sentence in order to clarify the types of nonprofit organizations that are intended to share fees under the new exceptions. Under the new exception are the same as those permitted to share court-awarded fees, and specifically referring to the phrase, quote, nonprofit legal aid, mutual benefit, and advocacy groups that are not engaged in the authorized practice of law. However, I must note that staff has made a technical correction to the sentence. Shortly after the agenda item was posted, staff received a comment from Toby Rothschild, who correctly noted that mutual benefit groups are organized as 501c6 entities, and advocacy groups are generally organized as 501c4 entities. So in order to conform the sentence with the black letter of the rule, the sentence now reads, quote, under the specified circumstances, paragraph A6 permits a lawyer to share with or pay legal fees arising from a settlement or other resolution of the matter to 501c3 organizations, such as nonprofit legal aid and charitable groups that are not engaged in the authorized practice of law. And finally, 2 ethics committees submitted comments stating that the proposed rule overregulates the sharing of legal fees in this context by requiring that an attorney must comply with the provisions of Rule 1.5.1, whereas when compared to the current exception, which permits the sharing of court-awarded fees, a lawyer is not even required to disclose to the client that the fee will be shared. In response to these concerns, the committee believes that because the fee sharing under A6 occurs where the fee sharing process is not public or subject to the protective supervision of a court, the additional client protective provisions found in 1.5.1 are appropriate in this context. And with that, this item requests that RAD recommend to the full board that the rule be adopted as amended and that staff be directed to submit the rule to the Supreme Court with a request that the rule be approved.
So moved, Steinbrecher.
I'll second that. Duran.
Brandon, you're muted.
Sorry about that. All right, so first by Alan, second by Ruben. Are there any further questions for Andrew or further discussion? All right, hearing none. Lisa, please take the roll.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Bertula,
Yes.
Wig,
Yes.
Steinbrecher.
Yes.
Motion carries.
All right, great. Thank you, Andrew, for all your work on that.
Thank you.
Okay, moving on to item E, review of metrics under the purview of the RAD Committee and Discipline System Statistical Report. So Lisa, please, this is about.
Hi, good morning, everyone. Really great, as always, to see you. So the September 2020 metrics report has been submitted to the Board of Trustees as an attachment to Donna's Executive Director report. And the metric report focuses on Q2 2020 and monthly metrics for June and July 2020. So there are two metrics under RAD's purview that did not meet their targets. The first one is a metric OPC-2A, e-learning courses. The target for that metric was for 85% of participants in the e-learning courses report that their courses met their expectations, and for the Q2 2020 performance was 76%. Based on comments provided in the open comment field of the course feedback survey, OPC believes that the lower overall satisfaction ratings is the result of course functionality experienced by some users. Those who encounter those issues tend to be more likely to submit a satisfaction survey after completing their course, and this negative experience appears to influence their overall experience, even if their rating of the particular course content was favorable. So OPC staff will continue to analyze survey responses to learn more about what changes they can make to improve participants' experiences. And the second metric that didn't meet a target was SBC-1, maintain annual caseload clearance of 1.0 or higher. This is a monthly metric, and June and July performance was 0.94 and 0.91 respectively. And as you can see from the explanation that the court provided, the court expects that this caseload clearance rate to remain irregular for the next several months while the court recovers from issues related to State Bar building closure due to the COVID-19 pandemic and related case abatements that resulted from the building closure and move to online court. In other metric news, I want to share that this fall, my team will be reviewing all metrics. We're going to review what metrics still work, which ones need to be modified, improved upon, added, removed. And our plan is to share our findings with the Board of Trustees and RAD in particular at the January 2021 set of meetings. And finally, this agenda item has as attachment A, the September Discipline System Statistical Report. This report contains 13 months of data where applicable for all metrics reported for offices within the RAD's purview, as well as additional analyses that describe important components of the discipline system. And I'll take some questions. We have staff available to answer questions about their metrics if you'd like.
All right, does anybody have any questions for Lisa or OCTC staff?
It would be OPC or State Bar Court.
State Bar Court.
Okay, thank you.
I think one thing that was of note to me was the, let me get to the appropriate page here, but the inventory of P1 and P2 cases, which have actually been reduced during this time. So I think that's something to highlight for the positives of this case prioritization system. I would like to thank the State Bar Court for continuing to be flexible and working with OCTC and Defense Counsel and getting these hearings underway. I know there are some court systems in California that have not reported to their full capacity, and so I think the State Bar Court in moving us in that direction has been a huge help in ensuring public protection. So thank you. All right, unless there's any other questions or comments, and hearing none, we'll go over to item F, which is the Regulation and Discipline Committee 2020 Work Plan Review. And Lisa, please take us through this.
Yes, okay, terrific. Hi, good morning again. I'm going to share my screen so I can show you all the work you did this year. Slideshow would be good. Okay. So this agenda item reviews the 2020 work plan that this committee approved at its January 2020 meeting. And I'm going to go through the list of items that were completed, and then I'll close with what are still forthcoming and what's pending. So first of all, one of the items on the work plan was to receive the discipline system statistical report on a bi-monthly basis, and my office did accomplish that, and this report is regularly issued to you as a RAD agenda item. Also on the work plan was for RAD to review the annual discipline report. Staff presented the 2019 ADR to the board on April 16th, 2020. Another task on the RAD agenda work plan was to consider ADR messaging and marketing, and board leadership provided extensive feedback on the 2019 ADR narratives and content and message. Also on the work plan was performance of the evaluation for Chief Trial Counsel, and RAD participated in a joint meeting with the Executive Committee in July 2020 for this performance review. Another item on the work plan was to consider a computational law logic model. OCTC engaged MITRE, which is a nonprofit company, to leverage artificial intelligence to automate legal reasoning and complaint analysis. Extensive work was done into reviewing their proposal, their research. OCTC reviewed this proposal, their ideas, their analyses, their conclusions with RAD leadership. And the conclusion was, unfortunately, that it's not really a viable solution at this time, given the limited efficiency gain and the costs involved. Of course, if conditions change, this option will be pursued further. And another item on the work plan was for offices under RAD's purview to give presentations to you all. And the following offices did give you updates, or their offices, what's going on with them, what's new with them. And those offices were State Bar Court and Office of Professional Competence. So forthcoming, we still have some work to do. And so I've scheduled that for probation and lawyers assistance programs to present to you in November. But the Client Security Fund will have to push their presentation to next year, 2021. Also on the agenda was a presentation scheduled for discussing of the OCTC hiring and retention, and that too is scheduled for your November 2020 meeting. And finally, on the work plan, we laid out a research agenda that my office would explore, and we'll probably have to carry that out in 2021. We've made progress in the sense that we planned some projects, we explored data options. We had a lot of more time-sensitive issues on our plate, a lot of work with admissions, for example. The CAPA project, for example, took up much more time than we expected. But the good news is that we did complete one issue with regards to this research agenda, and that is we were to explore the extent to which information is available in case file narratives for the purpose of extracting data that will inform research projects. And we did do that task. We did a random sample of about 100 cases and explored what's available. And we're very confident that moving forward, that any projects that would benefit from extracting information that are buried within case file narratives, we know where to find them, we know how to extract them efficiently. So in conclusion, this research agenda that we outlined in the work plan will be carried out next year. So something that needs to be completed today actually is this, the work plan agenda item about studying recommendations based on the Farkas report. So Professor Robertson did report recommendations to the board in July 2020. So in that sense that you did all study them. But there's one item regarding one of those projects that I believe Brandon would like to discuss with you today, and it has to do with how to, what to do with specific categories with regards to closing closed complaints to archive. And with that, I can hand it over to you, Brandon.
You're muted.
Sorry about that. You know, youngest person here still has issues with technology. All right, so Steve, can you please paint the picture for the board in regards to what we've done about the archiving of closed complaints?
Yes, of course. At the July meeting, the board adopted a resolution that said that OCTC should implement an interim reform that prior closed complaints more than 5 years old should not ordinarily be considered in evaluating and investigating a new complaint, with exceptions permitted based on a written showing to an attorney at the level of ACTC or higher, and that for purposes of this resolution, prior closed complaints do not include those resolved with a warning letter, directional letter, resource letter, or agreement in lieu of discipline. We have worked diligently to implement the board's July resolution. We've worked with ORIA to identify preliminarily cases that should be archived. That preliminary list includes more than 513,000 complaints. The State Bar IT department has worked with Tyler Technologies, the company behind our case management system, and they are developing a script that will add a security group, a flag, and an archived event to each case on the ORIA list. They will do that programmatically, so it will not take us 10 years to handle, to manually add those items to those 513,000 cases. But as we identified those cases, there were 3 areas that we felt we needed additional guidance on. And so we are bringing that back to this board to discuss, to get that guidance. The first is, should we archive cases that are otherwise eligible for archiving, but the respondent has another open, active case in investigation, pre-filing, or in state bar court? And there are 2 primary considerations for us asking this question. First, given that an open case is pending, there is very little risk that an intake attorney would forward a new complaint to investigation based on the closed complaint. Frankly, the open investigation, pre-filing, or state bar court case would be much more likely to impact that decision to forward the complaint to investigations than a closed complaint would be. And second, there is a strong potential for staff confusion if we archive a closed complaint while the respondent has an open investigation, pre-filing, or state bar court case. Essentially, they will be dealing with a respondent on one day, see their complaint history, that complaint is included in that complaint history, and on the next day, that case will be gone, which may result in some confusion. And so, however this board wants to resolve that issue is fine, but we wanted to bring that to your attention and get your guidance. The second issue is, should the archive date be based on 5 years from the original open date, what we commonly refer to as the CFR, or the complaint file received date, or should it be based on any subsequent reopened date? As this board may know, we occasionally reopen cases when new information is provided. And so essentially we just want to know whether the board would like that 5-year closure archiving date to be the operative original date or the subsequent reopen date. And finally, the third issue is, should we archive cases for dead, disbarred, or resigned respondents? And in the case of disbarred or resigned respondents, closed complaints are valuable, and we feel like we have a need to be aware of those to investigate should the attorney seek reinstatement. I would also point out that for deceased respondents, there's not the same value of those complaints because deceased respondents will not be reinstated. But like disbarred or resigned respondents, there is no risk that the respondent's new complaint, that a new complaint, would be either forwarded based on the old complaint, or therefore that it would contribute to any disparity in the discipline system. And what I mean by that is that we do not forward cases, we do not prosecute cases on dead, disbarred, or resigned respondents, because there is no other action as a regulatory agency of attorneys that we can take based on that conduct. As I mentioned, ORIA has identified at this point 513,000 complaints that would need to be archived. If we do not archive complaints for disbarred and resigned attorneys, that would remove 32,000 complaints from that list of 513,000. And I don't have a specific number on removing closed complaints about attorneys who are deceased or presumed deceased, but I presume that that would add many more as well. So those are the 3 areas that we would appreciate guidance.
And so given the notice requirements of our meetings, these would not be formal, a formal motion and then formal adoption, but we wanted to open this up for discussion among members of RAD regarding these 3 areas regarding the archiving of complaints. Does anybody, in some respects, this is really in the weeds in this particular area, but we wanted to open it up to any members of RAD who wish to wade in and offer any thoughts or guidance or concerns.
Brandon?
Yes.
This is Josh. I just have a real quick question. What maybe Steve, you could talk a little bit about what constitutes reopening a case. I have a little bit of concern that that may just be a huge exception that people could, not that anyone would intend to, but could potentially be taken advantage of. And so I'm just trying to understand what would constitute that and what's that trigger.
That's a great question. Thank you. So generally, when we reopen a case, it is a result of additional communication from the complaining witness. They will provide us with additional information that we would review and to determine whether it is something that is significant such that we would reopen the case and begin to investigate anew, or whether it is something that is maybe not new information, was included in the prior case file, or whether it is in fact new information, but it doesn't change, it wouldn't change the outcome of the case, or at least the decision as to whether we should investigate further or not. And so if the answer is yes, we should investigate further, we would reopen that case and move that case forward. And if it is not information that would change the decision as to whether we would investigate the case, or it was information that had already been provided to us, we would simply communicate with the complaining witness that, that our decision is unchanged and we would leave the case closed.
Just for clarification, so the complaining witness or information correspondence would have to be at a level that we would be making a decision to continue or at least begin the investigation again. Am I understanding that correctly?
Yes, ultimately the question is, just as with the with new cases that come in, whether there is a colorable claim of a violation of a disciplinable rule, so that we should move that case forward and continue the investigation to determine whether there is sufficient evidence to be able to prove that case. And if, for example, we make an initial determination there is not, and they provide us with additional information that makes us rethink that, then we, under those circumstances, we would reopen that case and move the case forward.
But the correspondence alone is not reopening of the case.
No, we make an evaluation based on the content of the correspondence. That's correct.
Understand. Thank you.
Any other questions or potential direction for Steve? All right, hearing none, we're going to have another discussion about various recommendations that Professor Robertson made in the full board agenda. So I know that this will continue to stay at the forefront of this body's attention. And I think with that, Lisa, do we need a motion to approve the work plan?
No, that was just a report out.
Okay. All right, so this concludes the open session agenda for the Regulation and Discipline Committee. And we will now go into closed session under business item 2A. And this is closed pursuant to Government Code Section 11126 sub C sub 2. And we anticipate that this will take approximately 20 minutes. And so all members of RAD should received a email from Lisa with the Zoom link for the closed session. And it's important that once we conclude and close that you reconvene back into this Zoom link, because this is the link that the regular Board of Trustees meeting will open into. So we will adjourn the open session and resume a closed session. So see you all on the other side. This is the RAD meeting. We are coming out of closed session. There's no action to report. And I think we can take about a 5-minute break and then resume with the Board of Trustees meeting at 10:30.
That'll be on the same link, Brandon?
I believe so. Louisa, is that your understanding, or DAG?
Same link.
Same link.
Great, thank you.
All right, we'll see you guys in about 5 minutes.